Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. In a time of change and uncertainty, e-Immigration's case management system and dedicated team are here to help you keep calm in the chaos. Talk directly with the award-winning e-Immigration team to see how their software can help you manage your cases, clients, forms, and firm with ease. Get a personal demo at get.eimmigration.com/demo or click on the link in the show notes. And of course, mention Immigration Review Podcast on your demo for a special offer. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Earlier this week, Senator Chris Murphy from Connecticut went completely ham on DHS Secretary Noem, giving a nearly 7-minute opening statement that is an absolute must-watch. Pork jokes aside, I do believe you'll find it quite fair and balanced. It truly is hard to argue with any of what Senator Murphy says, given that he at times seems willing to bend over backwards to assume that his political opponents and DHS are operating in good faith, but then explaining why what DHS is doing with many aspects of immigration is so violative of Congress's statutes and the U.S. Constitution. Seriously, give it a watch. Not sure how Senator Murphy became the Dems immigration guy, but he's definitely here. He probably has some pretty good people on staff, too. Also this week, the panel in GC v. Bondi, Ninth Circuit, amended its Episode 223 decision a bit after the Ninth Circuit refused to go en banc on the decision. Seems like Judge Sanchez in dissent wanted to. Big, non-citizen adverse one about particularly serious crimes, mental health facilities in Mexico, and more. Also last week, in the criminal law context, the Third Circuit held that courts can't rely on criminal docket sheets during the modified categorical approach analysis to ascertain the subsection of conviction, and that pre-sentence reports can't be relied on either, at least when a defendant objects to the factual basis of it. That's United States v. Payo, Third Circuit, April 28, 2025. And don't forget it. Having got through all that, 4 complicated decisions for all of you this week. I demand that you enjoy. And for all making the trip or already there, I can't wait to speak with you at the Federal Bar Association's Immigration Law Section Conference in Arlington, Virginia this Friday and Saturday. See you there. Listen now. Our first case this week is Ozturk v. Hyde et al., published by the Second Circuit on May 7th, 2025. It's really similar also to Mahdawi v. Trump et al., published by the Second Circuit on May 9th, 2025. You'll probably recognize both of these people. For purposes of the summary, we're going to do Miss Ozturk's case. This case is about habeas relief. You should know the names. This is the Tufts graduate student abducted off the street and put in an unmarked van. That is Miss Ozturk. Or as the Second Circuit puts it, quote, Rumesa Ozturk is a graduate student who had, until recently, been living in Massachusetts lawfully on a student visa. On March 25th, 2025, 6 plainclothes law enforcement officers arrested Miss Ozturk near her home without warning and drove her away in an unmarked car. Unaware of her location and unable to contact their client, Ms. Ozturk's counsel brought a habeas petition in the District of Massachusetts. The petition alleges that Ms. Ozturk was arrested and is now detained based solely on an op-ed she wrote over a year before her arrest, end quote. The U.S. government has never claimed otherwise, I believe. Turns out that by the time the habeas petition was filed, Ms. Ozturk had already been driven across state lines into Vermont. And when the government eventually disclosed Ms. Ozturk's location nearly 24 hours later, she had again been moved, this time to a correctional facility in Louisiana. Because of course. So the District of Massachusetts transferred the case to the District of Vermont, which set the matter for expeditious scheduling. As part of that, the district court ordered that the government transport Ms. Ozturk back to a detention facility in Vermont. Believing such an order an outrageous affront to the government's ability to do whatever it wants with non-citizens, the government appears to have interlocutorily appealed or sought an emergency stay of the transfer order. The Second Circuit affirmed the district court. More on Ms. Ozturk's background. She's a doctoral student at Tufts, here on a student visa. That she gives Tufts a lot of money, too. As the basis for her arrest and apparent revocation of her student status, DHS apparently, quote, made an assessment that she had been involved in associations that may undermine U.S. foreign policy by creating a hostile environment for Jewish students and indicating support for a designated terrorist organization, including co-authoring an op-ed that found common cause with an organization that was later temporarily banned from campus, end quote. Gonna stop right there. While neither I nor any individual can speak for all Jews, this Jew would politely ask that the administration stop using my community as a justification for its constitutionally violative immigration actions. If the law permits immigration imprisonment for discussing Israeli-Palestinian issues and nonviolently advocating for a particular side, both the Jewish community and America have lost and will lose far more than some think we will gain. Also, it's just plain wrong. Also, I'd be remiss not to mention the literal neo-Nazis who seem to feel so at home supporting the current administration, some of whom I believe stormed the Capitol in Mr. Trump's name on January 6, and some of whom may have received pardons from said Mr. Trump. But I digress, of course. This is about Ms. Ozturk, not a neo-Nazi. Ms. Ozturk's Non-Crime was a March 2024 co-authored publication, quote, criticizing the university's response to 3 resolutions passed by the Tufts Community Union Senate that would have the university acknowledge the Palestinian genocide, apologize for the university's president's statements, disclose its investments, and divest from companies with direct or indirect ties to Israel, end quote. For co-authoring a publication, she has been in immigration prison for about a month and a half and has had her visa revoked. Ms. Ozturk was not notified of the revocation, by the way, and the Department of State takes or at least took the position that it need not and will not do so in the future, I believe. Anyway, ACLU and a whole bunch of others jumped in as soon as they could, alleging, among other things, that the insanity of her detention and transportation throughout the American immigration prison system was, quote, unlawfully designed to punish her speech and chill the speech of others, end quote. You don't say. Her attorneys did not challenge her visa revocation or removability, though, so that's interesting but probably strategic. Seems like the district court's about to grant her habeas and bail, and of course again has ordered her transfer to the District of Vermont. That latter thing is what's at issue in this decision, and again, the Second Circuit affirmed the district court. It's a very long decision, and we've barely just begun, so here are the highlights. Because really it's all about stays, trying to stay something that a federal court or some court has ordered be done. The Nicken factors that non-citizens counsels always must argue to prevent our clients from being removed pending petition for review. Well, now it's the government that needs to satisfy the Nicken factors. And it can't, said the Second Circuit. The most important prong is usually the likelihood that the party seeking a stay will succeed on the merits, and the Second Circuit doesn't see a case for the government. Doesn't seem like the government's really arguing the facts or the merits either. It's all about jurisdiction. First off, yes, Ms. Ozturk technically sued the wrong people because Massachusetts ICE wasn't detaining her by the time that they sued. But, quote, any confusion about where habeas jurisdiction resides arises from the government's conduct during the 24 hours following Ms. Ozturk's arrest, end quote. So you can't win on that horrific technicality. Not to mention, explains the Second Circuit, that if it dismissed the matter on this technicality now, ICE could remove Ms. Ozturk immediately before another lawsuit could sufficiently proceed. Nor does Ms. Ozturk's later transfer to Louisiana deprive the Vermont court of habeas jurisdiction. The Supreme Court's decision in Ex parte Endo from 1944, quote, stands for the important but limited proposition that when the government moves a habeas petitioner after she properly files petition naming her immediate custodian, the district court retains jurisdiction and may direct the writ to any respondent within its jurisdiction who has legal authority to effectuate the prisoner's release, end quote. Good to know. Nor does the INA divest the district court of jurisdiction. To the meat of it. Mostly the INA Section 242A2B jurisdiction stripping provisions that we often discuss on the podcast, but to summarize lots of complicated analysis, Ms. Ozturk isn't challenging her removability, and the decision to transfer a detained non-citizen under INA Section 241G, even if a discretionary decision for ICE, is not one of the statutes that is expressly, quote, in the discretion of the Attorney General, end quote. There are specific statutes that use such language, like adjustment of status, waivers, etc., but without that language, explains the Second Circuit, the jurisdiction stripping provisions don't apply. Ipso facto, a habeas action lies to challenge unconstitutional detention transfers. Fascinating. Nor does INA Section 242G bar her case because she's not challenging her removal proceedings or something arising from it. Quote, instead, her petition challenges her unlawful detention, pending those proceedings, and she seeks her release from detention in the interim based on the violations of her First and Fifth Amendment rights that she has identified, end quote. And because the detention is allegedly, quote, retaliatory, end quote. That's how you do it, especially in the Second Circuit. No wonder they want to keep the case in Vermont. Just saying. Not to mention that ICE detained Ms. Ozturk before the NTA was even filed. Other jurisdiction stripping arguments were rejected too. Citing the KKTP's own Canale Media Holding LLC win from the 11th Circuit in 2020 as well, Episode 11. Just saying. You must be sick of jurisdiction. I know I am. Nor will the government suffer an irreparable injury by moving Ms. Ozturk from Louisiana to a different facility in Vermont. And I mean, come on. Let's be real. The government has no argument here. Immigration detention is immigration detention, right? We know that they have no argument because the best the government seems to be able to have mustered was that, quote, it suffers an irreparable injury any time it is enjoined by a court from effectuating statutes enacted by representatives of its people, end quote. In any event, Ms. Ozturk can very easily attend removal proceedings in Louisiana, where the government has forum shopped them to remotely from Vermont. The other Nicken factors weigh against the government too, including the harm to Ms. Ozturk in not bringing her back to Vermont. The Second Circuit also denied a writ of mandamus requested from the government against the district court. So, absent extraordinary Supreme Court intervention, Ms. Ozturk is returning to Vermont, where she stayed for one night en route to Louisiana. And obviously a must-read if you're filing a habeas petition, especially on issues of detention transfer. And as I mentioned at the top, on Friday, the Second Circuit published a similar habeas decision in the case of the Palestinian undergraduate student and lawful permanent resident, Moshe Mahdawi, who was detained at his naturalization interview and who has since been released from custody. And then on Friday afternoon, the district court judge ordered Ms. Ozturk's release. What a world. I don't believe she's been released yet, though, as of late Friday afternoon. And that is Ozturk v. Hyde et al. I feel like I might have let a little off my chest with that one. So next up is matter of Choc-Tut, published by the BIA. This case is about bond. Immigration detention. Bond. Mr. Choc-Tut got one for the relatively low amount of $4,000. Unhappy with that, DHS appealed, and the BIA said that the IJ was wrong. Quote, at the time of the immigration judge's custody determination, the respondent had multiple pending criminal charges, end quote. All driving related, and 2 were DUI charges. Very drunk both times. With charges pending, Mr. Choc-Tut appropriately pled the 5th during the bond proceedings, although counsel stated that, quote, the respondent began drinking after he lost contact with the son when his former partner became engaged to another man, end quote. So kind of the opposite posture from that Fifth Amendment case discussed last week, right? The respondent pled the 5th, but the attorney kind of admitted that the guy was drunk. Quote, the respondent testified that he did not intend to drink alcohol and drive in the future, and that he would rely on his family for rides, end quote. Believing the respondent and without convictions, the IJ deemed Mr. Choc-Tut not a danger, and a $4,000 bond sufficient to negate the flight risk. Indeed, explained the IJ, quote, the criminal court set a $1,000 bail, which was later reduced to $500, and did not indicate that the respondent was a danger to the community despite his 2 prior arrests in April and May 2024, end quote. So while it doesn't appear that the IJ deemed this binding, that is, the state court's findings, it seems that the IJ considered that the criminal court itself didn't deem Mr. Choc-Tut a danger and even issued a bond far less than $4,000. That was error, explained the BIA. Under DOJ's own regulations and the BIA's own case law that isn't actually required by Congress's statute, noncitizens have the burden in immigration bond proceedings. And IJs have, quote, broad discretion to consider any matter he or she deems relevant when determining whether a noncitizen's release on bond is permissible or advisable, end quote. But still no bond here. Quote, driving under the influence represents a grave danger to the community and is a significant adverse consideration in bond proceedings, end quote. The repeat arrests here, including being close in time to one another, show that Mr. Choc-Tut hasn't met his burden in this case. Remember that, though, when trying to distinguish your single DUI bond case. This case does not hold that a single DUI arrest requires a no bond finding. As to the criminal court stuff, quote, while an immigration judge may consider a state court's decision as to dangerousness and the amount of bail that was set in criminal proceedings, an IJ does not owe a state court custody order deference in immigration bond proceedings, end quote. Doesn't seem that that's actually what happened here, but in any event, quote, the legal standards for bail in state court may be different than in immigration court, and there may be a variety of reasons why an immigration judge may or should reach a different determination than a state court judge, end quote. So I guess the BIA is saying that criminal court dangerousness findings aren't due that much weight, because the burdens are different in criminal bond versus immigration bond proceedings, I suppose? Given particularly the, quote, repeated and serious nature of the respondent's actions, end quote, the BIA doesn't believe that Mr. Choc-Tut met his burden in this case. And not for nothing, he pled guilty to some of it while DHS's appeal was pending. And here's something that struck my eye. It appears that someone within DOJ may be searching for unpublished BIA decisions that have already been issued in an unpublished form for reissuance and publication. Because this is now the second time during the second Trump administration that the BIA has published a previously non-precedential decision at the behest of the Attorney General. If such an internal EOIR endeavor exists, I'd love to know what the criteria guidance is for identifying decisions to reissue precedentially. Anyone want to try a FOIA? Any former BIA members or staff attorneys want to talk? You know where to find me. I'll be in Arlington, actually, at the FBA Immigration Law Section Conference next week. And that is Matter of Choc-Tut. The last case before we take a break is Sandoval Argueta v. Bondi, published by the Fifth Circuit on May 9th, 2025. This case is about crimes of child abuse. late Friday publication from the Fifth Circuit. My favorite kind. Mr. Sandoval was admitted to the United States as a lawful permanent resident, it seems, as a child. He should have naturalized, but again, he was a child, so not really his decision. Because his parents didn't do it for him, his conviction as a young adult a decade after he entered the United States is a huge problem. 3 convictions actually, but the conduct is essentially the same. At 19 years old, he, quote, solicited sex over the internet from someone he thought was a 13-year-old girl, but in actuality was an undercover police officer, end quote. DHS alleged that he was removable because his conviction qualified as a crime of child abuse under I&A Section 237A2EI, possibly the most complicated and weirdest of all removability provisions. But then DHS withdrew that allegation and substituted a drug trafficking allegation. Looks like he had drug convictions too. And then, about a month later, a state court vacated the conviction. Having already been ordered removed for the drug stuff, Mr. Sandoval moved to reopen his removal proceedings, and an IJ granted the motion. Mr. Sandoval then moved to terminate his proceedings because he no longer had the drug conviction, and because the government had conceded previously that a minor wasn't involved in that other conviction. Which is true, of course. It was an undercover cop. So DHS amended again, this time saying that Mr. Sandoval had been convicted of 2 or more crimes involving moral turpitude, not arising out of a single scheme of criminal conduct. That's I&A Section 237A2A-II. This is all too much for a Friday evening. Why is it too much, you ask? Because DHS then amended its NTA again, a 4th time, and brought back the child abuse charge. Mr. Sandoval kept trying to terminate. He had a point, too, about the child abuse stuff, relying on, quote, matter of Jimenez Cedillo from the BIA in 2020, in which the BIA concluded, without analysis, that a crime of child abuse finding requires involvement of an actual child in the underlying conviction, end quote. But see, the thing is that the Fifth Circuit had already found, or soon thereafter found, that this very statute of conviction is a crime of child abuse. That's online solicitation of a minor in violation of Texas Penal Code Section 33.021C. And that's a Dec v. Garland, published by the Fifth Circuit in 2021. So shortly after Jimenez Cedillo. Applying Fifth Circuit precedent, which appears directly on point, a different immigration judge affirmed the child abuse from movability. The IJ also deemed the convictions aggravated felonies, barring Mr. Sandoval from almost everything, and then the IJ denied Convention Against Torture referral. And then the IJ denied Convention Against Torture deferral on the merits. The BIA affirmed, but not on the drug stuff. But let's just let that be. This week is complicated enough. A weird remand happened too. Mr. Sandoval lost again. He was physically removed to El Salvador, and then he moved the immigration judge to reconsider its child abuse finding. All of that was denied, and we're at the Fifth Circuit. Motions to reconsider can be considered, even when the non-citizen has been removed, by the way, held the BIA on appeal in this case. I'm skipping lots of procedural history, but that seems kind of important to me. At the end of the day, it all came down to Loper Bright, really, and not in a good way for the non-citizen. Recall, Mr. Sandoval wants everyone to follow matter of Jimenez Cedillo and not Dec v. Garland. Or for the Fifth Circuit to reconsider Dec given Jimenez Cedillo. But without Chevron deference, Mr. Sandoval doesn't have a great argument for why that should be so. Recall, Dec held that, quote, a conviction under Section 33.021C categorically met Section 237A2EI's definition of a crime of child abuse, end quote. True, the decision didn't actually discuss the fact that people can be convicted under that statute where no actual child is involved at all. But here, the Fifth Circuit believes that Dec's larger holding correct. Agreeing with the Fourth Circuit and others apparently, the Fifth Circuit held that, quote, the definition of a crime of child abuse logically extends to attempt offenses, end quote. And at the very least, that's what Mr. Sandoval did here, right? Quote, whether an attempt offense requires an actor to come close enough to completing an offense to constitute a reasonable probability that he will do so, end quote, is sufficient. And if the underlying crime is a crime of child abuse, so too is an attempt. Satisfied here. When a non-citizen, quote, forms a subjective belief that his online target is a child, and he nevertheless requests sexual favors from that online target, the non-citizen is intentionally attempting to cause harm to a child, end quote. And that is sufficient for removability. Well, though, what about matter of Jimenez Cedillo? Not much explanation from the Fifth Circuit, other than it's a, quote, unreasoned conclusion, end quote, that is, that a child must be involved, and that the Fifth Circuit doesn't really have to care anymore, legally speaking, after Loper Bright. And they're right. So Mr. Sandoval will remain in El Salvador. 2 notes. Remember DHS's concession before on withdrawing the crime of child abuse? Well, the Fifth Circuit held in a footnote in this decision that the doctrine of judicial estoppel didn't prevent DHS from recharging the crime of child abuse removability allegation. That doctrine, that is, judicial estoppel, quote, should be guided by a sense of fairness, end quote, explains the court. And also, courts are, quote, entitled, but not required, to treat concessions as a binding judicial admission, end quote. So there you go. Also of note, the Fifth Circuit joined the circuit party in a footnote noting that its prior precedent on point remains even if Loper Bright vacated the methodology used, that is, Chevron deference. Sigh. And that is Sandoval Argueta v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. And so we conclude with Calvary, Albuquerque Incorporated et al. V. Rubio et al., published by the 10th Circuit on May 6, 2025. This is a long case about R1 visas, religious visas. It's big, and it of course didn't originate in immigration court, but we never do ours on the podcast, so let's do it. Plus, as I was reading this decision, I was literally sitting in San Diego County Superior Court waiting to see whether the judicial gods would select me for jury duty. Do I have your attention now? I wanted to do the case because not only is it about our visas, but it's also mainly about the doctrine of consular nonreviewability. Remember that guy? The Supreme Court's Munoz decision from last term? Mr. Green is a South African clergyman. The nonprofit church, Calvary, Albuquerque, wants to bring him to the United States to serve as their worship leader. To do that, he needs an R1 visa. Now, previously, he had entered with a B1, B2 visa to see if the Albuquerque Calvary was a good fit for him. He led worship services at Calvary during the trip. He returned to South Africa, and Calvary applied for an R1 non-immigrant status for him with USCIS. While that application was pending with USCIS, quote, Calvary gave Mr. Green honoraria allowances as thank you gifts for leading worship on Sundays at the church, end quote. Shouldn't have done that. We'll see why in a sec. USCIS approved the R1 petition, but that doesn't guarantee a visa. Approved petition in hand, Mr. Green needs to pass his consular interview in South Africa. And that's where it went south. Africa. More on that in a sec. Now, on the one hand, we care a lot about religious freedom in this country. The Religious Freedom Restoration Act of 1993, the RFRA, provides that the, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unless it is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest, end quote. So that's a very high burden where religious rights are at issue. And the government entities where that applies to technically includes the Department of State. On the other hand, the Supreme Court said last term in Munoz that the doctrine of consular nonreviewability that it made up means that, quote, as a rule, the federal courts cannot review consular officers' visa decisions, end quote. Importantly, though, quote, the doctrine has two exceptions. First, under the expressly authorized exception, Congress may expressly authorize judicial review of consular officers' visa decisions. Second, under the constitutional claim exception, the Supreme Court has assumed that a narrow exception to consular nonreviewability exists when the denial of a visa allegedly burdens the constitutional rights of a U.S. citizen, constraining review to whether the consular officer gave a facially legitimate and bona fide reason for denying the visa, end quote. Pretty big mouthful to protect a constitutional right, no? Related to that, some circuits have conducted, quote, a more searching review of the consular officer's visa decision if a plaintiff affirmatively alleges facts with sufficient particularity to raise a plausible inference that the consular officer acted in bad faith, end quote. The 10th Circuit isn't sure how far the bad faith exception applies in the 10th Circuit, and it didn't decide here, given that it didn't believe bad faith adequately pled in the complaint. So that's all the really tough legal doctrine that the plaintiffs are going up against in this case. Now, on the third hand, we've got the INA, which among other things makes non-citizens permanently inadmissible, permanently, if they've ever engaged in or attempted immigration fraud. Mr. Green allegedly has that problem here. The Department of State's Bible, the FAM, explains that religious leaders can actually enter on B-1 visas to do, quote, missionary work, end quote, but they violate their status if they're paid to do it while on a B-1. So the allowances that Mr. Green received after that first B-1 visit are a potential problem that immigration attorneys should remember to advise their client churches of. Because it seems that when pressed on the issue, Calvary stated its, quote, sincerely held religious belief that ministers, including guest worship leaders, should and must be compensated as a central tenet of their faith, end quote. I bet they could have found a better word than compensated. Compensated shouldn't even be in the vernacular of entities engaged in B-1 visas. Like they shouldn't even know that the word exists. The consulate here first denied based on a belief that Mr. Green would overstay the time permitted by his visa, the dreaded 214B letter. All you can really do when you get one of those is apply again, which Mr. Green did with an attorney, but this time the consulate made the inadmissible fraud finding due to the payments that Calvary gave him related to the B-1 activities. INA Section 212A6CI. Could be wrong, but it looks like Mr. Green did a pseudo-appeal Department of State LegalNet inquiry, which affirmed the consular officer. State believes that Mr. Green misrepresented the purpose of his B-1 travel from the start, that he was trying to work. And because of all this religious institution, Calvary, will be permanently deprived of its chosen worship leader. Affirmed the split 10th Circuit. Mr. Green sued, and a district court dismissed Mr. Green's lawsuit based on the doctrine of consular nonreviewability. The district court didn't see bad faith or a constitutional claim, and additionally explained that the RFRA, the Religious Freedom Restoration Act, quote, does not extend to long-standing judicial presumptions and standards of review like the doctrine of consular nonreviewability, end quote. As I mentioned, the 10th Circuit affirmed. In one corner, we have religion. In the other, the doctrine of consular nonreviewability. The doctrine won. Love the argument, though. The Tenth Circuit goes on for many pages about the doctrine of consular nonreviewability, but I suggest going to hear it from the horse's mouth with Munoz on episode 217. It's a Supreme Court-created doctrine, of course. It's not jurisdictional, though, explains the Tenth Circuit, but it almost is. It's just a bar to review, absent narrow exceptions. To get around it, as a recap, Congress needs to expressly authorize an exception, or alternatively, a U.S. citizen's constitutional rights need to be violated and the consulate needs to have not provided a facially legitimate and bona fide reason for the denial, which is almost always satisfied by a mere citation to the statutory inadmissibility provision. If you can't meet those things, you can't even survive a motion to dismiss in federal court, it seems. And recall in Munoz, the Supreme Court held that Miss Munoz did not have a constitutional right to live with her spouse in the United States, even where that spouse had already been granted a hardship waiver. So it's like an almost impossible doctrine to get around, and not got around here. The RFRA stuff is most interesting to me, and likely the Tenth Circuit, because it really does seem like it might be a congressionally legislated exception to the Supreme Court's created doctrine of consular nonreviewability. We care a lot about religion in this country. Well, explained the Tenth Circuit, the RFRA's cause of action provision doesn't discuss Department of State or consulates at all. Yes, it applies to, quote, all federal law, end quote. But that's believed ambiguous to the majority. Congress presumably knew about the doctrine, and so it's got to expressly authorize suit to get around nonreviewability. That is, federal suit against the Department of State for consulate decisions. And here, the RFRA does not do so. Quite the standard putting on Congress, though. Not done with the RFRA to the majority. Also, to summarize many pages of analysis, the Tenth Circuit believes Congress more focused on burdens with the RFRA, not substance. After all, even before the RFRA, the doctrine of consular nonreviewability applied to First Amendment claims, explains the court. The implication, I suppose, being that Congress should have known that the doctrine could apply to First Amendment claims when it passed the RFRA. So if it wanted religion or other First Amendment claims to be accepted from the doctrine of consular nonreviewability, it could have said so expressly. Plus, foreign policy, am I right? Important stuff. And so, wide latitude for the executive. Briefly addressing Calvary's separate constitutional claim, even assuming it has one separate from the RFRA, the Tenth Circuit saw a facially legitimate and bona fide reason for the consulate denying Mr. Green's visa. 212A6CI, fraud or willful misrepresentation in the past. And in this case, Mr. Green and Calvary even know the factual basis. The salary and renumeration stuff from when he was here on the B1. Probably no authority to require consular officers to tell visa applicants the specific factual basis during a visa interview anyway, by the way, explains the Tenth Circuit in a footnote, but Mr. Green kind of knows the reason here. Maybe the consulate erred in deeming all of that salary rather than something else that is actually permissible with a B1. Maybe the consulate was wrong about what Mr. Green's intent was when he entered the United States on the B1. Maybe not. We'll never know. That's what the doctrine of consular nonreviewability intends. With bad faith not plausibly alleged, that was the end of it for Mr. Green and Calvary. Judge Bacharach dissented for 16 pages, believing that the, quote, all federal laws, end quote, part of the RFRA authorizes suit and gets around the doctrine of consular nonreviewability, at least of this stage of the lawsuit. So if you've got a similar issue in probably any other circuit, read Judge Bacharach's dissent and go to town to try to make some good law to get around the doctrine of consular nonreviewability. But not in the Tenth Circuit. And that is Calvary Albuquerque Incorporated et al. V. Rubio et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.